Hello ladies and gentlemen, and welcome to this webinar which will be considering the response of the Scottish Government to the consultation on the law of succession which was published in June 2015. My name is John Kerrigan. I am a consultant with Morisons LLP, Glasgow and Edinburgh. I took part in the advisory group which assisted the Scottish Law Commissioners in relation to, firstly, the discussion paper on succession of 2007 and latterly the report on succession of 2009, and I've had an ongoing involvement with possible changes to our laws of succession since then. Now, in June 2015, the Scottish Government published its consultation on the law of succession. It invited responses to that consultation document, those responses to be lodged with the Scottish Government by the end of September 2015. Thereafter, there was a considerable period of silence, with the Scottish Government not really indicating what it intended to do with the ongoing possible changes to our laws of succession. However, we now have a very much clearer idea, because on the 18th of October 2018, the Scottish Government published its own responses to the consultation on the law of succession. The 2015 consultation document was a weighty tome. It had 5 main chapters, one being intestacy, the next being protection from disinheritance, otherwise legal rights, the next being agricultural units, the next being protection of cohabitants, and the last being miscellaneous matters. The Scottish Government published 2 papers on the 18th of October. One is an analysis, really a statistical analysis of the responses to the 2015 consultation, and that can be found and accessed at www.gov.scot/resource, which has a capital R, /0054/00542137. Now that's quite an interesting paper, but the main meat of what I want to bring to your attention today is the separate document being the response, which can be accessed at the very same address, except that the final number is 00542-136. What did the Scottish Government say? Well, first of all, in its paper, it made reference to the fact that it had enacted the Succession Scotland Act 2016. That act was intended really only as a stopgap to try and cure some of the many anomalies which had beforehand existed in the Scots laws of succession, and take it from me, there were a number of them. However, the 2016 Act was never intended to be a root and branch reform of, in particular, our laws of intestate succession or our laws in relation to legal rights. Both in relation to intestate succession and the possible reform of legal rights, the Scottish Government gave a number of possible options. But it has now, I think, decided that in respect of some of those options, no further consultation is required. In relation to the question of the laws of intestacy, the Scottish Government feels that further consultation is required. However, the Scottish Government has given its view on 2 particular matters. And the first is that the Scottish Government, as a result of various surveys and the responses to the consultation of 2015, they are satisfied that 2 of their proposals should be enacted. And that is that a spouse on intestacy, and spouse includes civil partner, should inherit the whole estate if there are no issue. By the same token, if there is no surviving spouse or civil partner, the issue should inherit the whole estate. However, whilst the Scottish Government is satisfied that they can proceed with these particular changes to the laws of intestacy, because they were considered to be uncontroversial, there's going to be further consultation on other possible changes to the laws of intestacy. I think that the proposal which probably engendered the greatest amount of concern and friction was in relation to the possible reform of legal rights. Legal rights, of course, at present can only be claimed from the net movable estate of the deceased individual. And one of the proposals made by the Scottish Government was that the old differentiation between heritable property and movable property should be abandoned for the purposes of succession, and that the concept of legal rights, as we have known it for many years, should be abolished and replaced with the concept of legal share. And the difference between legal share and legal rights was that legal share could be claimed against the deceased's whole estate, including heritable property. Now, that particular proposal caused great concern in the Scottish agricultural community, for the simple reason that the main business model in the Scottish agricultural community remains the agricultural partnership. And some of you may be aware that Section 22 of the Partnership Act 1890 has a provision which is of direct relevance. And that is, and I'm paraphrasing it, Section 22 provides that unless otherwise provided, the interest of a deceased partner in the partnership shall, in any question with the surviving partners or any other person, including the deceased's personal representatives, be treated as movable in the deceased partner's estate. Now, the example I would give you, a partnership of 4 individuals, they've got a partnership agreement, is a very simple one, and it doesn't exclude the provisions of Section 22 of the 1890 Act. One of them dies. Now, they share profits equally. The farm is owned by the partnership. The farm is worth £6 million. The minimum interest of the deceased partner in the partnership is therefore £1.5 million. And if that is treated in the deceased partner's estate as movable, it is a huge fund against which legal rights can be claimed. So I think that if you look at a partnership agreement prepared for an agricultural partnership in Scotland, Section 22 is excluded. The concern in the agricultural community was that that particular protection, the exclusion of Section 22, would be rendered meaningless if legal share could be claimed against the whole of their estate, heritable and movable. Now, the Scottish Government, I think, initially had indicated that they were not necessarily content to consider excluding one particular Scottish business activity from the general laws of succession, and in fact that was what the Scottish Law Commission had themselves said, that they saw no social justice reason for excluding a particular Scottish business activity from the general law of succession. However, the Scottish Government, in its response on page 11, in relation to this particular problem, says as follows: the current scheme of legal rights attracts criticism, but it does have the benefit of striking a balance between testamentary freedom and limited protections for spouses, civil partners and children. Further encroachment on the autonomy of individuals would undermine their ability to manage their affairs as they wish. The alternative consulted on would attract a greater degree of criticism than the current system, given the lack of consensus about children's rights, and because of the viability concerns about the impact of the removal of the distinction between heritable and movable estate on certain land-based businesses. And this is the important point. The Scottish Government concludes by saying, on that basis, we do not intend to bring forward reforms in this area, which I think is a clear indication that we will continue to have legal rights as they have been understood in the past, and they will not be replaced with the concept of legal share. Moving on to the question of cohabitants. In terms of Section 29 of the Family Law Scotland Act 2006, cohabitants were given a degree of protection where one of them died intestate without a will. The 2006 Act under Section 29 allowed the surviving cohabitant to make an application to court, provided it was done within 6 months of the date of death, for transfer of property or payment out of the intestate cohabitant's estate. And Section 29 made it clear that the maximum award which a Scottish court could make was the same amount as if the cohabitant had in fact been a surviving spouse under Sections 8 and 9 of the Succession Scotland Act 1964, and also in respect of legal rights. Section 29 was, in my view, badly drafted, and there are two aspects of Section 29 which the Scottish Government have looked at, and the first is the time limit. The time limit is 6 months from the date of death. That is a peremptory time limit, ladies and gentlemen. If you don't raise your action properly within the relevant 6 month period, your right to raise the action has gone. There was considerable concern that families, the true beneficiaries on intestacy, when a cohabitant died, their relative, were deliberately doing nothing in the hope that the surviving cohabitant would either not know about their right to apply under Section 29 or would miss the time limit. The Scottish Government have decided that the time limit will be extended. It will be extended to 1 year from the date of death. Now, I would have to say, ladies and gentlemen, I find that disappointing, because it's always been my view that the time limit should be fixed with reference to the date of grant of confirmation, because that means there is no incentive on the beneficiaries on intestacy to do nothing. I had this argument when sitting in with the Scottish Law Commissioners years ago, and I pointed out that if they were simply extending the time limit but with reference to the date of death, then cohabitants in this country didn't have the same rights as cohabitants in England and Wales, because under the Inheritance, Family Provision and Dependents Act of 1975, a cohabitant can raise an action to ask the court to award them property or money from the estate, and that action has to be raised within 6 months of the date of grant of probate, which is the English equivalent of confirmation nominate, or letters of administration, which is the English equivalent of confirmation dative. You'll have noticed I referred to probate and letters of administration, and the reason for that is quite simply that under the 1975 Act in England and Wales, you can make an application to the court for an award of property or funds from the deceased estate, even if the estate died testate. And that was the second question which the Scottish Government looked at. Should Section 29 of the Family Law Scotland Act be extended to testate cases? I have always not favoured the extension of Section 29 to testate cases. However, the Scottish Government have now made it clear that they do not propose to extend Section 29 to testate cases. They say, and I'm quoting, "We are persuaded by the points made against allowing a claim by a cohabitant in a testate estate, and will therefore make no changes in this area, ensuring no further encroachment on testamentary freedom, preserving individuals' ability to arrange their affairs as they please." So we have clarity on that. The consultation response document of 18th October goes on to consider miscellaneous matters, and the first is the Scottish Government had asked if capacity to make or revoke a will should be determined by the law of the testator's domicile at the time of the making or the revoking of the will. The Scottish Government recorded that there was significant agreement, 83%, to the proposal, and they therefore intend to legislate to make this change. Some of you will know that in the Succession Scotland Act 2016 there were changes made to the Conditio Si Institutus Sine Liberis Dececerit. The old common law version of the Conditio was abolished, but a new statutory version was introduced. That's under Section 6 of the 2016 Act. But there is a second Conditio, the Conditio Si Testator Sine Liberis Dececerit. Initially, the viewpoint of the Scottish Law Commission was that that Conditio had fallen into desuetude and should be abolished. However, a large number of people disagreed and argued that the Conditio still had a place. It was a protection in some circumstances for children. And the Scottish Government, having considered all the evidence and the responses, have stated, and I'm quoting, on the basis that the rule may still serve a useful purpose in certain circumstances, we will not legislate to abolish it. Another miscellaneous matter was aliment juri representationis. That is to be abolished by statute. Another consideration was temporary aliment. And the Scottish Government's position is that temporary aliment from an estate does have a practical utility, and they will not abolish it, but will consult further on it. Another matter was equitable compensation. A very difficult doctrine to understand. Many of those who wrote in response to the 2015 consultation had said that they thought equitable compensation should be abolished for once and for all. The Scottish Government's response, and I'm quoting, "We will not bring forward any changes in this area because Section 7 of the 2016 Act has been enacted since the consultation. Section 7 provides for a new rule governing the vesting of the fee where a life rent terminates other than on death, which removes much of what was left of the potential scope of the equitable compensation doctrine. And so whatever mischief arose from the continued existence of the doctrine has therefore largely been removed. We will test this position when we consult on a new approach to intestate succession." Another question which was asked was, in Scotland, what should be the effect of marriage or civil partnership on a will? The Scottish Government had asked if marriage or civil partnership should result in the revocation of a pre-existing will. 22% of those responding said it should be, 70% said no, it should not revoke an existing will. The Scottish Government have responded by saying, "We will therefore not make any change to the law in this area," i.e., if you have a will and you get married or enter a civil partnership, that will not revoke your will, which of course puts our profession on notice that we should still be saying to our clients, do you realise you've got a will that may not cover the fact that you're now married or have entered a civil partnership? The Scottish Government also considered whether or not a sheriff should have the right to refuse to appoint a particular executor nominate. But they say in their response, "We do not plan to bring forward changes for executors nominate as we believe the testator should continue to be free to choose someone they trust to carry out their wishes, but see paragraph 67 below." And what does that say? This is the final paragraph of the response paper, and I'm coming to the conclusion of this webinar. But paragraph 67 is very brief and says, "We also intend consulting on a number of other issues which have arisen since the last consultation. These will include, but may not be restricted to, information publicly available after a grant of confirmation, and the position of executors to their murder victim's estate. That's a reference to the unfortunate McTaggart case, which has received recent publicity, where a son who was found guilty of murdering his mother and sentenced to a minimum of 18 years had been appointed as executor nominate under her will. Obviously he had forfeited any benefit in her estate under the Forfeiture Act of 1982 as amended. However, the Forfeiture Act 1982 did not prevent him from acting as executor nominate, and suffice it to say that has caused problems in the administration of his mother's estate. That's all today, ladies and gentlemen. Thank you for listening in. If you have any queries or points you would want to raise, I'm happy for you to contact me direct on 0141 3325 666. My email address is john.kerrigan@morisonsllp.com. Thank you very much.